Okay, friends, today we're going to be going through the buyer representation agreement and some other ways that you can be assisted as a buyer consumer with the help of your real estate agent friends, specifically the Tennessee Realtors, here with our Tennessee Realtors forms. And I'm going to be walking you through the RF 141 first. So this specific form is going to be the exclusive buyer's representation agreement, meaning that you, the consumer, have entered into an agreement with a brokerage firm and they have appointed a designated agent. In most cases, that's the buyer's agent that you have already started this relationship with. So let's get to it. All right. The first section is specifically who, the what, the when, and how are we going to do this little tango that we're doing. So first up is going to be the firm that's representing the whole transaction, along with the buyer. Now, the buyer could be an entity. It could be something like an LLC or a corporation, but it could also be a person's name. So just know that if you're an agent and you're watching this, the buyer's name is not always going to be a person's name. It could be an entity's name as well, especially if the buyer is purchasing a property through their LLC or similar entity. Now, the agreement is going to begin on this day, which we call the effective date. So once it's signed, it becomes effective and it carries through until there is a termination. Now, the termination is going to be listed here on the bottom, and termination is appointed by local time. And we're going to talk about local time in a little bit, but local time is specific to the firm, which is a little different, I know, than what I've said in my purchase and sale agreement videos. And that's because for a purchase and sale agreement, they have one timeline, and here for the buyer's rep, we have a different timeline. Confusing. I know. It's okay. Let's get to it. Next up is going to be just some general information that you, the buyer, have told the agent, this is what I'm looking for. Maybe you want a 3-bedroom, 2-bathroom, single-family home, the white picket fence, the whole 9 yards. What do you want? What are you looking for? What can they help you find? And then, what's the budget? Is there a range of budget? Is there an up to amount? What type of financing is going to be used? What type of properties do they need to exclude from this search? So that way the agent can narrow in and tailor the experience specifically for you and this search. Now, there might be some exemptions to the agreement, meaning that this buyer is going to be represented through the agreement by this agency and this agent, but they're not going to be represented should the buyer proceed with a property that is, in this case, maybe an example of a for sale by owner or a foreclosure or a property that's under auction. Now, the client does have some duties, and the client is going to be determined by the buyer upon the execution of this agreement. Until then, they're just a customer. So the buyer agrees that they're going to purchase the property exclusively with this buyer broker that they're agreeing to work with. Now, this comes up often where the buyer is like, oh, I don't know if I signed an agreement with an agent, or they did know they signed something, and they tell another agent they did not sign. So in this section 3, you're clearly understanding that as a buyer consumer, that you're not going to go cheating on your agent and working with another agent until this one has canceled. Now, the buyer, you are also responsible to furnish in a timely manner all documents and personal information that's going to be needed for the transaction. Majority of the needs are going to be on the financial institution side, meaning with your lender, but the buyer broker may also need important information, and it needs to be timely because the entire purchase and sale agreement is what we call time is of the essence, meaning everything has a timer, and if you miss a deadline, you're in default as the buyer. And when you're in default, that means you got to give up some money. And sometimes it means you land in court and you get sued by the other side. So let's not go there, okay? Let's keep going. Next is going to be that the client is not under an exclusive buyer's rep with somebody else, meaning you didn't have this thing signed with somebody else, and now you're going to sign it again with this agent. And then if you want to terminate or need to terminate, there's this termination clause here for section D. And we're going to talk about the form that goes along with this termination, which is the RF 151 here in just a little bit. But it does state here that the buyer agrees to pay all costs incurred by the broker and any other amount agreed to upon through a cancellation fee. We'll talk about that fee and what that is later. Now, there is a carryover clause listed here, and carryover clause gets a little confusing. You've signed this buyer-broker agreement that starts, and then it also ends. But what happens after it ends? Well, if you have not signed a buyer-broker agreement with another agent, then at that point, you have this carryover clause. Meaning, if you turn around and go back to a property the buyer-broker has already previously shown you, engaged you with, or have been what we call procuring cause, the chain of events leading you to that property, then this carryover clause that's in place is going to apply for you. So let's pretend that this is 10 days. You have a 10-day carryover listed here. Your agreement terminates. You turn around and you go back directly to listing agent and you say you want to write an offer unrepresented. Well, if you're within your 10-day window, you're unrepresented, yes, but you still owe the originating firm buyer broker compensation. The only way that this is exempt is if the buyer then enters into an agreement with another licensed real estate agent. Okay? And I got to highlight it for you because I think the agents forget about it and the consumers don't realize it's there. You're under this carryover clause except when the buyer signs another buyer agency agreement with somebody else. All right, let's keep going. Compensation, ooh la la, oh my, we have been fighting over compensation like crazy, and it's like, what is happening here? So let's dive in. If you've watched my other videos, there's lots of things going on about compensation, more specifically that the rules have changed as of August 17th, 2024. There was a huge class action lawsuit, and so the National Association of Realtors ended up having to change some of the rules. Now, here specifically in Tennessee, we already had this form of written notice to the consumer in our agreements already. Some states did not. What we did do is we had a few word changes and we added a few extra things just to make it a little bit more apparent to the buyer. Meaning, instead of all of this information being in a paragraph that you would just read through, it was then become into a bulleted format here like an outline. So let's go through it. First up, broker compensation, all negotiable. I don't care what anybody says. It's negotiated. Now, here's what you might have is a buyer broker may approach a consumer and say, here are the services that I render, and these services cost blank. And the blank could be a dollar amount that's a set amount, or it's a percent of the purchase price. Either way, the consumer can come back and say, great, thank you. But what if I don't need some of those services and I want to exempt them? Can the fee come down? At that point, the buyer and the consumer go into negotiations. Now, the buyer does have the opportunity here through the compensation for seller or from seller section to say, hey, if I start working with you, I want you, the agent, to negotiate on my behalf with this seller over here during the transaction for this fee to be covered by the seller. And that is allowable. But what could happen is the seller says, I will cover a portion of the fee requested. And at that point, then we have what's called a difference. And when there's a difference involved, the buyer is responsible for the balance, and it's due at closing. Now, the balance difference could be negotiated to not occur. And if that happens, then that would be in the stipulation of this agreement, or it's negotiated and amended to the agreement at a later date upon the execution of an offer. Now, if the buyer ends up leasing, the buyer might agree to pay the buyer broker a flat amount in compensation unless otherwise negotiated. But no, there is a cap on compensation. What? Yep, there's a cap. Meaning, if the agent puts a number or a percent on line 45, they can't receive more than that at all. There's a cap. So if this number is negotiated, great, even win. If the seller says I'll offer a portion of what is requested, the buyer's on the hook for the difference. But if the seller says, hey, as an incentive to this property, we are already offering cooperative compensation of the amount of blank, if that amount is greater than the amount listed here on 45, the agent can't receive the offered amount. They can only receive what's in the buyer broker agreement. Now, VA buyers, those are for our veterans. Let's talk about you guys for a second. For the longest time, the Veterans Administration had put a stop on buyers being allowed to pay buyer broker compensation. It was considered a non-allowable. However, with all of these changes that have been going on after the lawsuit, the Veteran Administration, which we call the VA, has put a temporary memorandum out allowing the veterans to pay buyer broker compensation. It is not considered a non-allowable. However, should the memorandum be reversed, then at that point, it's going to go ahead and be a non-allowable again. But until the VA makes changes, we don't know what's going to happen. And at this point, if you're a veteran, just know things have changed. All right. The 707, which is our additional contract language I bring up in all of my videos, there is a new clause right here that talks about how the buyer broker can negotiate through the purchase and sale agreement for the seller to pay the amount requested. And so this is just a little clause that they're going to put into their purchase and sale agreement. You can check out my other videos to see how this one works. Now, the broker fee is earned at the signing of both parties agreeing to purchase, lease, or exchange of properties. So if the buyer, you guys default and you void the contract, that broker fee is still due. You're not off the hook. You now owe the brokerage firm the amount that's negotiated here in the section that we just noted. So just know that if you go on default status and you terminate the agreement under default pretenses, you still owe the broker compensation. Now, let's talk about agency for just a quick second. Every state is different, and so I like to go over this a little bit deeper for the understanding, because we have so many people moving to Tennessee, and they're like, but that's not how we do it in blank. Well, that's cool. I'm glad that state does it like that, but here in Tennessee, here's how we do things. So the term broker is going to mean the Tennessee real estate broker or brokerage firm of which the brokerage affiliated licensees are affiliated with. So what the heck does that mean in kindergarten version? The word broker throughout the whole thing means the principal broker and the brokerage that the agent is affiliated with. Point simply. Now, the agent that you're most likely working with is the designated agent of the office that's appointed by the principal broker. So you do have some offices that have a managing broker, and they might also appoint the agent too. But more commonly, it's the consumer saying, I want to work with you. And the agent's like, cool, I'm going to write this thing up and I'm going to review it with you and we're going to sign it all together. And it's you and the agent signing everything together. But the actual legal agreement is with the agent's principal broker and firm and you, the consumer. All right, let's keep going through transaction and facilitator brokerage. This means that the agent is not the agent for either party. We actually automatically default to facilitator status through the Tennessee Real Estate Commission's rulings and through the law here set forth in Tennessee. And so all agents are facilitators by default and shall only become a designated agent through the signing of the RF 141 or equivalent form. Now, the agent might have an opportunity to go into dual agency if their firm allows it. Some firms do not allow dual agency, meaning they already have a signed agency agreement with the buyer and that buyer wants to go offer on a property that same agent is the listing agent, meaning they represent the seller. If that happens, the agent has to figure out what to do, and we're going to talk about that here in a minute. Agents in Tennessee are also bound by the law to disclose any adverse facts. Well, what the heck is an adverse fact? It's pretty simple. There's three things that determine an adverse fact. The first one is going to be having a negative impact on the value of the real estate. Okay. Is it also going to have reduced the structural integrity of improvements of the real property? And the last one is, does it present a significant health risk to the occupants? So if either of those three things apply for this property and it is recognized by a competent licensee, they're responsible by the law to disclose it, even if the seller does not. Okay, we're not talking about Megan's Law. We're not talking about stigmatisms. Those are not adverse acts, and those actually are not under our law to disclose. That's for the buyer to figure out on their own. The agents are only bound under the law by these three things. Now, we do have confidentiality built into our agreements, and there's another subsection that allows the buyer to disclose to the agent that they can then disclose to other parties certain information. Otherwise, they have to zippy zip and locky lock. Okay? This section here is going to be what I call working with somebody. And so you might see this on the RF301, which is the working with a real estate agent. These are the duties owed to all parties to a transaction. So you do not have to be a client of the real estate agent to receive these 7 items. This is actually built right into the Tennessee Real Estate Brokers License Act. And so all of these duties here, an agent has to provide to everybody, regardless of their agency status. Now, once they become the agent for the buyer through their agency agreement, that buyer now becomes the client of, and we call this working for. And so when you're working for somebody, you now owe them the remaining duties. Now, we do have a section here under agent disclosure. During the effective period of this agreement, the client shall not contact the listing agents directly. So if you've got questions about a property, don't call the agent on the sign. Call the agent that you've signed your buyer rep agreement with, and they will make arrangements for any questions that you have, showings of the house, and also providing you any additional information that you might need to know about the house, such as the property disclosures or any flood and elevation certificates that might be needed. Now, in the event that the client comes into contact with the seller's agent, it happens. You might be there touring it on a weekend at the open house. It happens. Hey, the buyer client, it's your responsibility to let them know, I'm already represented. Oftentimes, they're going to ask you to sign in at the open house, and they're going to ask you, are you being represented by an agent? The checkbox is yes, I am. Should you sign one of these? Okay, if the client purchases a property covered under this agreement, and it's not with the agent that's in this agreement, the consumer client is responsible to pay the original firm all of the broker compensation set forth in this agreement. So if you go cheating on your agent, you owe the bill. Don't do it, guys. Don't go rogue and cheat on the agent, because you're going to be responsible for the bill. They can come after you for the total compensation that is owed. Now, we do have some appointments here. Like I stated previously, you're going to have the broker of the office appoint a designated agent. And so that agent gets listed here on line 156. And sometimes when they're working on a team or a partnership, both agents' names will be listed here. There might be a situation where a subsequent agent needs to be appointed. Sometimes this happens if, God forbid, something happens to the original designated agent and the managing or principal broker needs to appoint a different person to get it to closing. They can go ahead and reappoint another agent within the firm. You also have a situation where maybe an agent leaves the firm for whatever reason. The agreement is still with the firm, not with the designated agent. And so at that point, the broker at that time will reappoint another agent again to get it to closing. But what happens when you have that situation where the buyer's agent and the seller's agent are the exact same agent? Well, here we go. You're going to have this section where it defaults to facilitator status on the buyer side. So if you are a buyer and you fall in love with a property that your agent has listed, your agent on the buy side will default to facilitator status for the showing. Should you want to offer on the property, at which point you will let them know, I'm ready to offer, then the agent will then go ahead and disclose their agency status, either defaulting to facilitator, leaving you unrepresented on the buy side, or going into dual agency status if their office allows it. There's a form, the RF303, that is signed for this, and all parties sign depending on which direction you, the consumer, the agent, and the consumer on the other side all agree upon. Now, if at this showing, you're like, not for me, then at that point, the agent automatically resumes their original agency status and going back to defaulting to representing the buyer or representing the seller through their individual agency agreements. No forms needed. It only happens if after the showing, you say, not for me. Here's that subsection for confidentiality where it allows you to ask the broker to disclose certain things. Sometimes on the buy side, this would be, hey, can you please let the agents or the seller know that we're going to be relocating to the area and our preferred closing date is blank. That would be applicable here. Now in Tennessee, we do hold earnest money, what we call trust money, and this money is held in escrow and it goes into an account and it's held until closing. There are only 5 terms where the earnest money can be dispersed and released once it's received to the office, and one of them is closing. Another is through the negotiation between the 2 brokers should a conflict arise. Otherwise, the buyer and the seller will then sign what we call a mutual release agreement, and they will decide who gets the funds. Sometimes the funds get split, but otherwise, if there is no agreement between the closing, the 2 brokers, or the consumer saying it'll go one way or the other, at that point, then it goes to interpleader and the courts determine what happens with the funds. That does go through a legal process, and so it is usually best to try to negotiate and get that worked out on the front end. Now, we do have some limitations on brokers' authorities and responsibilities, and so I want to just kind of highlight a few of these items here. What might happen? Now, the broker that's representing you, the buyer, might show the exact same property to another buyer client that they're representing. This happens in a market where we have low inventory or in a price point where there's low inventory, in which the buyer agent may represent the same situation with one buyer and another buyer, and sometimes multiple buyers. During the pandemic, we had it where you, the agent, may be representing 5 different buyers for the exact same property. Okay. Through our confidentiality, we're not allowed to disclose the terms of any of the offers. And so therefore, the agent's going to work with you and just let you know, hey, we're going to write this offer. What are the terms you want to negotiate for me to put into this agreement? And then they will go ahead and proceed. They cannot tell you the terms of their other clients' agreements. Sometimes it gets tricky, and sometimes at that point, the agent will ask another agent to step in to help the consumer negotiate the contract. So that way they're not put in a position where they might be negotiating terms, knowing what the highest and best offer is for one client and not being able to meet a highest or better offer for the second client. So sometimes a secondary partner comes in on those transactions. Okay, you also need to understand that the agent and the broker are experts in real estate. They're not experts in all matters. And so therefore, there might be some issues that kind of arise. And so it lists all those things, and that it is the buyer's responsibility to notify and do disclosure on any of the items listed in the paragraph B. Things such as verifying the square footage through the appraisal, checking the acreage through a plat map or a survey, ensuring that there's no hazardous or toxic materials in the property. That would be things like a lead-based paint or a mold sampling. Those are all things that the buyer is responsible for, and the broker is not responsible to do or to assist with. They may provide you some contact information on other people who do that, but just know that it is the buyer's responsibility through their inspection period to do all of those things. Okay, now the next 3 sections, C, D, and E, all talk about how the buyer broker is set underneath a very strict law. We also have commission rules and the National Association of Realtors Code of Ethics, in addition to federal fair housing regulations. So there are a lot of rules that we have to abide by. Now, at any point in time, if the consumer asks the agent to do something that is against any of those things, the agent shall not comply, and the agent will have to let the consumer know, unfortunately, I cannot do that because it's in violation of whichever one it falls under. Now let's talk about Section 9 real quick. It got a full rewrite this year, as you can see, strike through lines and basically rewritten by the attorneys. And this is going to be for our friends that are with sanctioned foreign businesses, governments, and non-resident aliens. And so if you'd like more information on this section, please check out the Tennessee Code Annotate, Statute 66-2301. Now you're going to have a section here about not being an expert assistant. This kind of goes in further with the conversation we were just talking about. And you're also going to sign an RF 304 disclaimer notice for most of the offices. It's a 3-page document that goes even deeper into each of these items. And the agent may supply you with the vendor list, which is the RF 711. Now, there's going to be some legal terms in Section 11. Specifically, the terminology is where I want you to hone in on. The terminology used throughout this agreement is going to be deemed on calendar days that end at 11:59 p.m. Unless otherwise specified. And the local time that is specified in this agreement is going to be determined by the location of the firm. Now, the purchase and sale agreement is the location of the property, but this agreement is the location of the firm. And so we do have Eastern and Central time here in Tennessee. And since these are state forms, that is why it's determined by a location of the firm or the property, depending on which agreement you're in. You also have some additional information about fair housing here on the bottom. And we're going to have another disclaimer about legal documents. P.S. These are all legal documents. You break the legal documents, you end up in front of a broker or an attorney. Never fun. Don't do it. All right. 13 talks about exhibits and addenda. Most oftentimes in the buyer representation phase, you don't often have this, but should you need to attach an exhibit or an addenda to the buyer amendment is going to be here. And those are going to be starting with a 5 or a 6 in your series for the agents. Special stipulations. This is where the agents are not allowed to be attorneys. They can't add any additional information here that is outside of their office clauses, system clauses, or anything that their broker has allowed to be placed here. Oftentimes here in the stipulations, you're going to find situations where if they're working on a team, additional team members are going to be listed. You might also have a situation where there is a cancellation fee that's predetermined. That's all going to be listed here as well. Any additional items that need to be placed in this preceding section shall control, meaning they change whatever was written before this. Now the signatures go here. So you're going to have the agent and their firm along with you, the buyer. And then let's jump into the next one. Now you're like, Kayla, hey, love you, but we're not signing the RF 141. I don't want to be under buyer's representation. That feels icky. I don't know the agent yet. I want to get to know, like, and trust them. Cool. You do you, boo. Let's talk about some other options you have. First one is the RF 143. That's a written agreement with the buyer before touring a home. Remember, August 17th of 2024, all the rules change. You want more info? Check out facts.realtor. Facts.realtor. Whole plethora of library information about all the changes. So you have the option to change this, sign this form. It's a non-exclusive agency agreement. It looks kind of like the 141, but you also have the option. This is a new form that came out this year called the RF 145. This is the buyer's touring agreement. So the touring agreement is very simple. I love this form because it's so easy, but this form does not establish agency. So if you're wanting representation where the agent will work for you, you need to sign a 141. But if you're okay with just a one-time show or a one-time tour agreement or something along those lines, or maybe I only want to work with you for a short period of time, and if this thing works out, then I'll sign the buyer agreement, cool. You can do that too. The agent is going to ask you to sign the buyer touring agreement. Consumers are no longer allowed to tour properties in the state of Tennessee and many states across the country after the settlement changes came out without a written agreement. You don't have to be under a buyer's representation agreement, but you do need to be under some type of written agreement. And so this is a one page, if you print it front and back, that has written agreement, understanding what the compensation is that's due, What are the terms, terminology that you need to have? And if you're an agent, come closer. I'll share a little secret with you. Print this bad boy out, front and back, super easy. Get a clipboard. You can get one of these at Walmart. Super easy. They open up. You put your touring agreements inside, and then that way when it's in your car, you have them on the go. So when someone calls and says, hey, I want to go see that house, you're like, cool, I've got my documents already. You don't need to get on the computer and do it. You can just do it right on a piece of paper. Do it on the hood of a car. We used to do it all the time with our other documents. Super easy. You don't need a hood of a car if you have a clipboard. I keep mine right with me all the time. Got the pen attached to it. Easy. Sign, seal, open up that lockbox, go show that property and sell it. Let's go. So you're like, which one should I do? 143 or 145? My recommendation, go 145. It's a little bit easier. All right. Remember we talked about that 151, your mutual release from the buyer's representation? Well, here you go. This is what it looks like. It's got some signatures on the bottom, but the meat and potatoes of this form very specifically state what the cancellation fee is that the client or the customer is responsible to pay, and it's due upon execution of this form. Meaning, buyer says, I want out before it terminates. They can. The only person that can release them from the agreement is going to be the principal broker. And the principal broker will say, that's great. The cancellation fee is going to be blank number of dollars. Once the amount is paid, the signatures are received, buyer's released from the agency agreement, and they can go ahead and work with somebody else. Okay, it's due upon execution, and only the principal broker is allowed to terminate. All right, friends, that's it for the buyer representation agreements. My next video that we're going to dive into is going to be on property condition disclosures. That's the 200 series for my agents. And if you have any questions, put them in the comment. Make sure you hit subscribe so you can get the little bell to check out all the videos when they come out every week. Thanks for touring along. And if you have any questions, let me know. See you on the next one. Bye.